welcome you. My name is Theominique Nottage, and I'm joined by Professor Lucy Reed, Panos, Camilla, my co-chairs, and Raul, the Global Events Director for Young ICCA. And we just want to welcome you to Tips from the Top, an interview with ICCA President, Professor Lucy Reed. She became the ICCA President just last month in May 2020, and she is a member of arbitration chambers in New York as an independent arbitrator, and she also has experience in the markets in Hong Kong and Singapore, and she used to be the head of the Freshfields International Arbitration Group. She has a very wide and expansive career, both in the professional market and as well as an academic, and we're very happy for her to join us today for this interview. We're going to be going over a series of themes, specifically mentorship and networking in international arbitration, women in arbitration, her standout career moments, how to make a career in a jurisdiction different from your home jurisdiction, tips on how to get your first oral pleading experience, and efficiency and due process in international arbitration. So the format of the webinar will be that we will ask questions on these different topics, and at the end we will take live questions. So you feel free to put questions in the chat bar at the side, and we will take those questions at the end. And if everybody is ready to go, we can start with the first topic of mentorship and networking in international arbitration. Professor Reed, what advice would you give a young practitioner on how to ask someone to be their mentor?
Thank you, Theo. I should say first that I'm no longer a professor, so you shouldn't call me Professor Reed anymore. In Singapore, they're very, very particular about the title of professor, so I guess I'm an honorary or an emeritus, a professor emeritus, although I still think like one. The advice that I would give if someone asked me, particularly a young ICCA member, about selecting a mentor is to throw the question back and say, why do you want a mentor? What is it that you think you need from a mentor? Do you want career advice? Do you want practice advice? Do you want a sounding board? And think, based on those answers, I would think about whether an appropriate mentor would be someone senior or someone mid-level, or often a peer. I shouldn't say just, someone with whom to exchange ideas. So I guess I would ask that the prospective mentee think carefully about his or her reasons and motivation for wanting a mentor, because mentoring is a huge universe of relationships that can be very different.
Thank you for that. My next question, do you still maintain a relationship with any of your former mentees?
The short answer is yes. The longer answer is that I have had various mentees in my life, including in my first law firm, which was quite a while ago, where the idea was with a mentor was more like putting a lawyer who'd been in the law firm with a new entrant to explain where to go to lunch, what partners to avoid, ways to behave. That's one kind of mentoring. And I played that role many times. And within Freshfields, I was an official mentor a few times, usually to members of another practice group for various reasons. I never had official mentees in the Freshfields International Arbitration Group, but I had a large number of young associates whom I helped train and help bring along, who I think you would consider, in the broader sense of the term, mentees. And I'm very close to many of them, many of whom now lead arbitration groups around the world. And in order to be very focused on statistics, to answer your question, I have been on email or phone already last night and this morning with 9 of my close Freshfields associates on matters. So I keep in touch, and I don't know, I guess I'm like a parent. I'm incredibly proud of their successes and happy to help them over the bumps in their careers.
Thank you for that. So you mentioned that you had an informal mentee-mentor relationship with a lot of associates at Freshfields. What exactly do you look for in a mentee?
What I look for in a mentee is a proactive mentee. I don't, particularly at this stage in my career, I don't think that the most active person in the relationship should be the mentor. I think the mentee should be asking questions about what he or she wants and needs. And when I'm rather a tough love kind of mentor, when in a mentor relationship, I will assign homework and say, you need to sit down and do this, this, and this, and make a list of whatever the topic or the issue is, and don't expect to hear from me again until you do your homework. I'm rather demanding um, in that relationship. And if someone wants to be a mentee just in hopes that I can get them a job in international arbitration in some practice around the world, I'm afraid I would fail dismally, because that's not what I consider a mentor-mentee relationship.
That's a very good point. And you spoke about being a very tough mentor. So we want to know, who was your mentor when you were coming up and you just started out in the field of international arbitration, and were they as tough on you as you are on your mentees?
Well, as I predicted, Theo, I'm going to disappoint you, because I've never had a mentor in my career. And that's not just because when I started, before most of you were born, or probably all of you were born, when I graduated from law school and qualified in 1977, there wasn't really that much emphasis on mentor-mentee. And I wasn't doing, there wasn't an official international arbitration group, for example, where I was. But what I have had incredibly valuable are senior lawyers, both in my first law firm and at the State Department legal advisor's office when I was there, who, one, I emulated them. I watched the lawyers I respected to see how they acted, how they practiced law, and tried to copy them in my own way. Point one. Point two, they opened doors for me. They gave me, in the sense of, they gave me opportunities. They said, you're going to have to do this oral argument. You're going to have to take on this role. Because they were confident that I could do it, and I wasn't always confident that I could do it. So they didn't lead me. They didn't lead me by the hand. They more pushed me and said, "It's time. You're ready. Go for it." So I really value those relationships, and a couple of those people are, not in this world anymore. But I do think of them in probably every day when I'm writing something, or when I'm preparing an award or preparing a negotiation. They've really had a major influence on me by letting me stand side by side with them and follow in their footsteps.
Thank you. I think that's quite an important point you made. And you also said that, when you first started practicing, that there weren't any official types of groups that supported mentoring. We know that you recently signed up to be a mentor of the Young ICCA mentoring program. So what are you looking forward to most in your role as mentor?
I thought about this question, and the reason that I signed up, well, there are three reasons why I signed up. One is, as president of ICCA, I really think I should do it. And now that I'm not a professor of 100 students at a time, or leading an arbitration group of over 100 associates, I've sort of refreshed myself, and I feel like I have an energy and a need to work with young practitioners again. The second is, I want to know more about why people join Young ICCA, what their aspirations are, what they expect from the organization, and how I can learn from that to make ICCA a better organization, big ICCA or old ICCA, whatever you want to call it, as well as Young ICCA is. And the third is, I feel strongly that all of the young arbitration groups should move away from the old format, if you will, of asking the old people in arbitration to come to cocktails and give war stories. I think that the young practitioners should do what Nigel Blackaby and Constantine Partizaitis did when they did Young LCIA, which was to start Arbitration International. Well, not that again, of course, but I want to see the young practitioners write collaborate on writing projects, have substantive discussions, focus on best practices together with almost, I would view myself in a mentor role there at Young ICCA as a shepherd almost, to help steer the young practitioners in those directions.
Thank you for that. You indicated earlier in your response that as president of Young ICCA, you thought that it was important to start being a part of the mentoring program, and you mentioned ICCA several times. So we know that Young ICCA is under the auspices of ICCA. So what would you say to one of our members who is uncertain of the value of joining ICCA as well?
I would say two things. And I'll have to start with an anecdote. When I was a brand new lawyer in my first law firm in Washington, D.C., which is long since closed, for worse, there was a senior international lawyer there named Don Wallace, who taught at Georgetown University, who worked with our international practice. And he said to us, you have to join the ABA. You have to join the ABA and the international law section, because if you don't, you can't really say you're an international lawyer, which comes down to the reason that I use in my classes, which is what I call JB, which is just because. If one wants to be a recognized international arbitration lawyer nowadays, I think it's important to be seen to be a member of the community that is the ICCA organization, membership organization. It's just a given, particularly with the low rates that we give young practitioners. And the second reason is connected. That is to join the community and get the benefit of keeping up with not just the fantastic things that Young ICCA does, but having more opportunities to get involved in the publications, the task forces, and the committees of ICCA proper. So I feel strongly about ICCA spending the money that we spend and the energy that we spend on supporting young ICCA activities, which are extraordinarily high in quality, but that's not either or. I think being a participating member of the main organization at some age is very important.
Thank you. So would you say that networking is important in international arbitration?
It is important. It's important for various reasons. Mostly I think it's important because it's fun and it's expanding to be involved in the discussions of what other people are thinking and what issues are coming to the top. I think it's occasionally important for getting a job. And the reason I say that is I have had myself many experiences, or I shouldn't say many, a couple experiences where I've just been chatting with someone when I've been looking for a new position or thinking that I haven't been happy in what I've been doing. And just mentioning it leads to a chain of discussions that says, oh, we didn't know that you were thinking of it. I'm aware of this opportunity. Let me introduce you to so-and-so. Many more times, I have been talking to a young practitioner and realized that I know of an opening somewhere, whether it's an NGO, whether it's a law firm or whatever, that might be just what they're looking for. So it's the word of mouth opportunity of networking that I think is more important than aggressive job hunting. The other thing is, you haven't asked me this, but I'm going to offer it anyway, as anyone who's watched other interviews or been taught by me will know, I think it's very important for young practitioners to try to publish, ideally collaboratively with other people, one important analytical piece, whether it's a blog, whether it's a law journal article, whether it's even publishing sometimes a memorial in a moot, to show the ability to think, to write as an advocate. More important than a lot of, cocktail receptions or parties or little tiny tweets. And the networking allows small groups to get together to do that, because it's very hard to write alone, I think, unless you're an academic. It's more productive and more fun to write with another person or a small group of people. So that's my kind of networking. Maybe it's not so mainstream, but that's how I view it.
Yeah. You also said that networking it can be fun. So what is your single most favorite arbitration network event if you have one?
The few times that I've done with the speed dating kind of networking, I've really enjoyed because we used to do it in Hong Kong and sometimes in Singapore because it's a way to get to know a little bit about a large number of people right away. And one of the things that I think distinguishes the international arbitration community, maybe that's a term that's overused, is there are people who are so different, not just from the cultures that they come from, but from their interests and their hobbies and their ideas. And we're all type A and we're all outspoken. So it's very easy to hear a lot of interesting ideas in a evening of speed dating. Some crazy ideas, but that's all right.
That actually sounds like a fun idea. Maybe we can do speed networking on webinars or some creative way to get that done.
Oh,
So
I think, yeah, you should get some programmer to, swap the boxes at 5-minute intervals or whatever. And the other thing I want to mention, if you don't mind, Theo, is I've been thinking about Johnny Beater this morning for a number of reasons. And years ago, there was an anniversary of the New York Convention where there was a big conference at the UN in New York. And it was the first time I experienced a program where each speaker was given only 5 minutes to say something important about the New York Convention. And my reaction at the time was, how can that be? You can't do anything in 5 minutes. Actually, the contributions in that conference were so focused and so on point and so helpful that they've stayed with me a lot longer than 50 or 75-minute lectures that I've heard since then. I think it's like a skeleton argument on steroids. You really have to focus in on what you want to say. And it's socially and culturally similar in a speed dating situation.
yeah, that sounds like quite a good idea and something interesting that we can consider for the future. I have just a few more questions under this topic area. How do you think the current pandemic and the increased use of modern technologies will impact mentorship and networking opportunities in international arbitration?
I think we've all shared the experience that we can stay connected relatively easily, in fact, quite easily, through Zoom and other platforms. Now, of course, we're the privileged people who have the computers, have the internet, have the time, have the ability to work from home. I think we've found that we can be more inclusive and people can participate in many more short seminars and conferences than they could physically, having gotten on airplanes. You can tell there's a but in my voice, and the but in my voice is going to be that we have to be careful of exhaustion, particularly with the competition among the institutions and others to try to keep relevant by offering this, offering that. It's like all day long you could watch Zoom conferences. So I think there'll be a flight to quality. I think the substance and the focus on real merit in using the technology will be important to watch.
I think that's a fair point, especially what you said about there being so much saturation and competition among the different organizations to deliver webinars of value. And speaking of the different institutions, do you think there's any value in joining multiple professional organizations for international arbitration?
You mean from a young practitioner's perspective?
Yes.
Well, I don't know. I see CVs that have a list as long as my arm of memberships in this, that, and the other organization where I know that one person cannot be active in all of those organizations. So I would urge, if I were still at Freshfields, I would urge the associates to join a handful of organizations where they can have a role and an impact. And I would be more impressed, if I were hiring, looking at a CV with someone in young ICCA and maybe, it could be young ICC or young ITA. I won't rate those, but I'd rather see someone showing interest and commitment to a handful of organizations than a whole long list. And excuse me for selling, but ICCA is the most important organization because it doesn't sell any services. It's not outselling arbitrations. It's a gathering of like thinking and different thinking, people interested in international arbitration.
Thank you.
By the way, I should admit something terrible about saturation of Zooming. I think it was on Friday afternoon, I got a message from one of my own 2 children saying, would you like to have a Zoom call tonight? And I said, no, I can't stand another Zoom call. To my own child, I said that. So there you go. By the way, I relented, and we did have a good conversation.
Thank you. I think we would be ready to move on to the next topic now. Camilla?
Yes,
Hi,
thank you,
Camilla.
Theo. Hi, good morning, Professor. So we would like to move to discuss your standout career moments. And Theo tried to summarize your stellar career in a couple of minutes, which is basically impossible. So I would like to start from the very beginning, and I would like to know what was your first introduction to arbitration?
That was at my first law firm in Washington, D.C., which I joined in 1979 after clerking for a judge. It was called Waldhar, Crater, and Ross. And I think, if I remember correctly, I worked on one ICC arbitration. Those were the days where you could only find ICC precedents in one of 2 books that weren't even indexed. And then my law firm, for reasons too complicated to go into here, was retained by 40 US companies to bring arbitration claims under the UNCITRAL rules at the Iran US Claims Tribunal. And I spent a lot of 2 full years working on a case for Phillips Petroleum, which was then private, against the Islamic Republic of Iran, doing what we now recognize as a run-of-the-mill treaty case for expropriation and breach of contract, DCF. So the work came to our firm, and I was at the firm. So it was luck followed by using luck.
That's excellent. And so another question that we had, and I suppose you partially answered it already, but what is your memorable moment of your first 5 years of practice? A hearing, the award of this case you worked on for many hours, I suppose. Any memory of that time?
Well, this came up the other night with all the troubled situation in the US right now. I think the most memorable moment of my young career was I had taken on a case pro bono representing a battered woman in the Ethiopian community in DC, and went to court. It was the District of Columbia trial court, not even a federal court, to represent her. I got the witnesses, including her pastor, other people, into this crowded courtroom all by myself. And it was on my birthday, actually. I remember at the time standing up with my knees shaking a little bit in court to do this case on my own. It was my first oral advocacy as well, and being profoundly disappointed that, as has happened a million times since, that the judge in that case refused to enforce the protective order against her boyfriend on grounds that he needed to keep his job, and therefore he should be free to go back into the community despite incredibly aggressive threats against her, and then assisting her family in getting her out of the country, basically. I did a fair amount of sort of criminal work pro bono when I was a young lawyer, and chose not to practice in that area full time. It was just too emotional. So that's what jumps out from my young career.
Maybe it's not for now, we will go back to this point, but I think it would be interesting, and it's my curiosity as well, perhaps to hear from you whether you would recommend to our members and young practitioners to focus as well on pro bono cases in order to develop their advocacy skills that can be used in arbitration. I don't know if you want to answer now, it's slightly separated from the standout career moments, but I think it's a good moment to ask these questions.
I don't know what the opportunities are now as much as I did when I was practicing in New York or DC. What I do know is, because I'm thinking of some other questions that will come up, one of the downsides of practicing in a jurisdiction outside of your own jurisdiction is that you cannot practice in the local courts. And so so for example, in Singapore, I couldn't take on pro bono representations. I could do a little work behind the scenes, but a Singaporean lawyer would have to do the actual advocacy in litigation. That is a downside. I know in the US there are many volunteer arbitration programs in the courts, which I used to urge my associates to join. So they'd have to go sit in the courthouse for a day for a referral or not, but it was a great way to get on your feet experience. So, of course, and I think I'm a big believer in public service, and I'm a big believer in pro bono work as well. So I would urge people to do that.
Excellent.
But I think I know that coming from the US, we have a lot of opportunities that don't exist in other countries. So I wouldn't want to be on a soapbox about it.
Yeah, thank you. So speaking again of your stellar career, you also had a moment where you were, and you still are, a professor. So we would like to know from you, if you have felt your greater accomplishment as a professor or as a practitioner? What you enjoyed the most, in a way?
Well, I enjoyed them. I enjoyed them both. I enjoyed everything except grading about being a professor. When I took the position at NUS, I'd been an adjunct several times before anyway, but one of my close friends said to me, you know, Lucy, all you do is teach at Freshfields. You're all day long, even when you're representing a client, you're teaching and leading the young associates in their development. So in that way, it actually didn't feel that different. And at NUS, I was a professor of practice. So my courses were interactive, not clinics, but very interactive, trying very hard to teach these LLM students and the LLBs how to do a case, what to focus on, how to negotiate. So it wasn't that different. One thing I miss now that I've been away from it for half a year is all the interaction with young lawyers and wannabe lawyers. Now, there are a couple I'd rather not see again. Let's just be honest. There's always a handful.
We appreciate the candor. Thank you. So you've had a lot of professional appointments, arbitrator, counsel, professor, as we said. What have you learned the most, and what is your sort of tip for us as a young practitioner on the basis of your experience?
That's a really hard question. I was thinking, for reasons I won't go into today, about my good friend Johnny Veeder, who had such an impact on so many people, and that underscores what I believe, which is that all of you have to be, first and foremost, yourselves. You have to be true to your style of thinking, your style of advocacy, your style of collaboration. It's very exhausting to try to pretend to be someone you're not, or, you know, if I can't be Johnny Veeder, I can't be my friend Toby Lander. You have to believe in yourself. So that's one very important lesson. A second is, I've often said this more to women, I have to say, than to men, and that is over-prepare. Always practice. Even now, when I give a lecture, I will do it out loud a few times in the mirror for myself. I don't believe that I deserve to stand up and have people to listen whatever I happen to feel like saying at the time. I want to provide substance. And I think, I guess I maybe should have said this first. It's important that you enjoy what you're doing. One of the reasons that I so enjoy a career mostly in international arbitration is, as I've said before online, it's the last refuge of the generalist. Every case is different. We've got different people, different nationalities, different sectors, different tribunals, different bodies of law, always refreshing, not doing the same thing over and over again. And I'm someone who likes that. Other people I know, I have friends who only do tax filings, and they say, I can't believe you don't feel insecure having to learn so many new things. I enjoy my life better doing the same thing over and over, but I'm more of I guess a dilettante, which is why I enjoy it. But I can tell you that when I'm sitting as arbitrator, I immediately listen better to someone who is engaged in what he or she is doing. They don't have to be super experienced advocate or slick advocate, but I can tell that they know their case, they like their case, they like their clients, they're happy to be in the room, and it compels attention from a tribunal. Long answer, sorry.
No, it's fantastic. Thank you so much. I think we are all taking notes. So I think it's a similar question, but I think still important. So obviously you have achieved a lot in all these years, but I'm sure you also had your challenges, and you made it, of course. So can you tell us what was your biggest challenge and how you managed to overcome it?
Gosh, I think the biggest challenge that I had in practice concerned a situation that I know better than to talk about in front of more than 100 people, because it was so fraught. But I'll say two things though. One is, yes, I have had challenges and I've had major disappointments in my career. And when I was co-chair of the partner recommendation committee at Freshfields Worldwide, one of the questions I always asked people was, tell me about a time that you failed, a time that something really did not go well. And I was very nervous about people who had always had a smooth life with no disappointments or failures. And it's not that you got a B instead of an A in one course in law school. It's something more important. So I think that you have to accept the setbacks, and the key thing is whether you learn from them. A different kind of answer I'll give you is the most challenging thing I ever did in my career in international arbitration was in the publicly known Libanonko v. Turkey case, which is a Nixon case you can read about, a very famous case where we represented the Ministry of Energy of the government of Turkey against an investor who, by the end of the day, was proven to be 10 times over fraudulent in every way. However, it was a very emotional, politically charged case. And at one point in time, the relevant prosecutor for the government, was charged with wiretapping the opposing counsel. And in fact, their email addresses were on his court-approved wiretapping list. And he had put in an affidavit saying that he hadn't done this, and I was called upon to explain to the tribunal how this had happened and why it was forgivable and correctable. And I don't think I got 5 words out of my mouth before I was cross-examined for about 90 minutes on obviously a terrible situation for a lawyer. And I'll remember it to my dying day, I'm sure, as the most difficult professional argument I've ever done. And from this comes a lesson, which is that my reputation served me very well. That I was at the time, I think, president of the American Society for International Law. I'm known to be straightforward, to tell the truth, not to hold back. And that's so important to protect in your career, is your reputation, even if it means losing clients, even if it means stepping back from things. And it's one of the reasons that everybody hears me now saying to the young practitioners, don't rush to get an appointment as an arbitrator in a major case if you're not ready, because people will remember if you don't do a good job. And a young practitioner can't do a really good job in a very big or important case. You need to take the baby steps before you get into the big cases. Because protect your reputation, you'll never get it back. You'll never get it back.
People remember mistakes.
Back on the soapbox, sorry, but I could still see the room where I was trying to present that argument. Fortunately, I had Brian King on one side and Utku Joshar on the other, who were a fabulous team.
Excellent. I think we may move to the next part because we are running, unfortunately, out of time. So I would leave the floor to Panos, and we're going to move a little bit away from you and your career. And with Panos, we will discuss efficiency and due process in international arbitration.
Yes, thank you very much, Camilla. And thank you very much, Professor Reed, for all your candid answers so far. Yeah, so the topic that I would like to discuss with you is efficiency and due process in international arbitration. And I know that this is a topic that deserves its own webinar. We can talk about efficiency and due process for hours. But what I wanted to ask you is whether you think that arbitration proceedings have become less efficient over the last couple of decades.
I think I'm in the minority here in saying that overall, I don't think they've become less efficient. I think that the examples of grossly inefficient cases are so well known that they take all the light away from the hundreds and hundreds of arbitrations, many of which I'm aware of from having been a vice president on the ICC court and watching proceedings proceed really quite efficiently. I've come around to view it a joint responsibility for counsel convincing their clients that efficiency will help them rather than not, and a firm tribunal to solve the problem, or at least to manage the problem.
Okay, and when you're sitting as an arbitrator, what tools do you use to make the proceedings more efficient? Some of us have heard about the retreat. Others have heard about Neil Kaplan's suggestion of having early openings. What are the tools that case management techniques that you use to make proceedings more efficient?
Well, I use techniques like the Reed retreat to be sure the whole tribunal is well prepared before a hearing or a conference. I'm trying to use Neil Kaplan's opening argument, early opening, but the pandemic has postponed all of my major attempts in that way. I'm exploring trying to use costs awards, interim costs awards, as a way to impress upon counsel what the price will be of their tactics. And I believe in page limits, which put a lot of pressure on the counsel and don't save time, but they do focus the issues better.
And do you think that the current use of technologies will improve efficiency? I mean, we all know right now that there are many virtual hearings taking place. So, I mean, I assume the answer is yes. But what do you see happening in the future once this pandemic is over?
That's a question a lot of people are looking at. What I predict is that we'll see the benefit of breaking up a hearing. And even if we can have an in-person hearing for the witness testimony, there's still a benefit for having the opening arguments being online without the necessary travel and the necessary extra days in the venue. I think we'll all see the benefits, and I've used this myself, of having a witness who's only going to be examined on 1 or 2 points for under an hour. Why bring that person for 3 days or a week to a foreign venue? Why not use the technology? So I think we'll see, maybe a hearing will still last a week, but it won't be 8 hours a day for a week, because pieces can be done online, and arbitrators and counsel and young practitioners who are proficient at maximizing the use of online, which means don't get exhausted and sit on your sofa, as I am, because everyone else is asleep, too long, to be more succinct. I'm pretty positive. I once watched a cross-examination in the Eritrea-Ethiopia Claims Commission of a surgeon in Ethiopia who came out of the operating room for 15 minutes of cross-examination. Can you imagine requiring him to travel to The Hague for a week with everything important that he was doing? And I also think that whoever's developing not just the coronavirus vaccine, but 3D video conferencing is going to make a ton of money if they get it right.
I think, yeah, we all agree with you on that. Another question that we have received relates to what we have seen over the past few months and weeks, namely arbitral institutions and networks issuing protocols, rules, guidelines on virtual hearings, on how to prepare a virtual hearing, on how to organize it, what tips a young practitioner should take into consideration. Do you think that it would be a good idea for all these networks and institutions to sit down together and come up with a uniform approach?
I think this is a bit cynical, but I think most of the arbitral institutions have trouble cooperating too much because they are selling and they're legitimately mostly competing for customers. Therefore, I think the IBA or ICCA or both are more likely conveners and collectors of this tsunami of new practices, just as the IBA and ICCA have proven to be in the past on other issues that cut across lines.
Okay, thank you. And one final question in relation to efficiency, and I know it's a very tough question to answer, but how does one balance efficient and due process in international arbitration? And I have some examples in mind. For instance, what if you start an arbitration, you receive from the parties the draft procedural calendar, and you see that the parties are proposing a 3 or a 4 month document production phase. Do you step in and you say, no, this is too much, this is going to delay the arbitration, and try to convince the parties to speed up the process?
The answer is, in most cases, yes, the tribunal should at very least press the parties as to why they need that much time. I would say in my experience, in about 10% of the cases, there's enough complexity that document production, for example, or memorial drafting, particularly for a government, will take that long. But I'm always surprised as chairperson, especially when I press on whether that time is needed, to how quickly the council say, no, not really. We can redo it and make it shorter. But I think one of the tensions that you can't ignore is that if the procedural calendar is so tight at the demand of the tribunal that there's going to be extension request after extension request, and then you need to find a new hearing date, that's worse than having a long calendar at the beginning.
Mm-hmm. And going back to the page limit point that you mentioned before, what was the reaction of the parties? Did they comply with it? And did you suggest it at the beginning of the arbitration, or was it at a later stage?
They always comply or ask for an exception when a tribunal sets a page limit. I use it more for skeleton arguments, for post-hearing briefs on targeted issues. I've tried and failed to get page limits on memorials. Council don't seem so willing to do that. That's one of my next projects. As I've said before and recently, the US Supreme Court, you only have 30 pages. Really, why should I have just gotten a 400-page memorial last night in a case? I'm not sure. But some cases require it. There's no doubt about it. Toby Landau and I agree on that. Some cases do require it.
Thank you very much. So yeah, I can go on with these kind of questions for quite some time, but I think in the interest of time, I'm gonna give the floor back to Theo, who is going to ask you questions about women in arbitration.
But one thing, I gave my Freshfields lecture in 2016 on the abuse of due process. in international arbitration. It was probably the best lecture I've ever written and given about how claims of due process are abused and why tribunals shouldn't allow that to happen to extend and complicate the records. So I think it's fun reading, and I urge people to take a look at that lecture if they want to know what I think about that.
Great, thank you.
Theo.
So far, we've talked a lot about your career in arbitration and your challenges and mentorship and networking and your thoughts on, different things going on in arbitration. So one thing we haven't talked about is you as a person outside of your career. So I wanted to know, if not you, who would you be?
That is a hard question. I think if I hadn't done what I did, I would want to be the female Anderson Cooper, to be a serious international media person. Because my husband's a journalist and a lot of our friends are journalists, and there's a similarity between the curiosity that leads to a trial lawyer or arbitration counsel or arbitrator and reporters. But I'll have to let my hair go white first, I guess. So I'm working on it, believe me.
Thanks. So moving back to women in arbitration, we just mentioned at the beginning that you just started your ICCA presidency last month. So how do you think you will influence women in arbitration through your ICCA presidency?
Well, we've actually just issued a joint report with Carolyn Lamb and others with on gender diversity. I will say this, ICCA will continue to promote women both in the Bureau, in the membership, and for preparation for appointments. That conversation is ongoing. It's robust. When 35, 40 years ago when I started, there were barely any women in arbitration. Now it's on the table. Now there are many up and coming, and they did it themselves, right? The pledge was done by women. The arbitral women was done by women. It's on foot, and I'm very excited by it, although I don't think we can take our attention off it. I am trying to focus more on national and regional diversity in arbitration, whereas I see it, we're now where we were with gender 25 or 30 years ago. The conversation is it's just not robust yet. It's nowhere near robust, and it's going to take a lot of work and a lot of training and a lot of education to bring along fairly people from developing jurisdictions into the community, other than having them sit in a chair and listen to what other people have to say. It's action that matters. It's involvement that matters, not just attending.
So based on those comments, do you think that there's true gender parity in international arbitration? And if not, what should women arbitration practitioners, particularly those from emerging jurisdictions, do, or what can they do about that?
No, there's not gender parity, because we know there's still only the magical, whatever it is, 13 to 15% women on tribunals and in institutions. And as head of international arbitration, well, actually, there's a lot of women who head international arbitration groups. I think it's a question of staying the course and continuing to support each other just relentlessly in development of women. And as I sometimes say horribly, people die. And so the top old generation of arbitrators will be disappearing. And there's a lot of room in the next generation for more women who are well positioned already. One of the things I love about Young ICCA is seeing literally hundreds of names of people I've never heard of, but who are in the field, and getting the opportunity to see what they're doing so that I can promote them more by name instead of just by the category of gender. But I do get discouraged. Get discouraged. I see lists of arbitrators, candidates in various roles of mine, and I have to ask again and again, put women on that list. There are no women on that list. You just can't let up your guard.
Yeah. So I would take away from those comments, I do think that women should support one another more and there should be greater camaraderie amongst women in arbitration. So are there any women in arbitration who you would say inspire you or you've looked up to throughout your career?
You know, I'm pretty much in the first generation of women leaders, so I can't say I got inspiration, but close friends and colleagues with, and huge respect for Brigitte Stern, Carolyn Lamb, I'm sure I'm going to forget people, Judith Gill, Loretta Malintopi, Gabrielle Kaufman-Kohler, my colleague, of course, Jean Kalitsky, and they're people who support other women. It's very important. I'll tell you a quick anecdote. I'm sitting in a tribunal right now with 2 women and 1 man. I'm not going to give out the names, but we've been issuing some decisions with dissents and we've had disagreements. But the man sent an email the other day saying, I only want to sit with women now. It's so much more collegial and intellectual and productive than my all male tribunals. So I told him he didn't have to go that far, but I appreciated that this really is how women professionals interact. I rarely see competition among women or lack of help of one woman to another. And when I do, I think it's really unforgivable.
Thank you. We are running very tight on time, so I want to move on to the next topic area. Camilla, if you will.
Sure, thank you, Theo. I think we are moving to a topic which may be of interest for a lot of the members who are listening to us. And actually, we have received a couple of questions in relation to this topic, which is indeed how to make a career in a jurisdiction which is different from the jurisdiction where you've studied or where you have qualified. And I think that it's a real question, particularly because I think we also represent the category of practitioners who have moved away from their home jurisdiction in order to be able to practice international arbitration. So one question would be, what is the biggest competitive advantage to entering an arbitration market away from your home jurisdiction? And is it a choice that all practitioners should do and consider, or do you think we have to distinguish between practitioners coming from, let's say, more developed arbitration jurisdictions than others?
I think the biggest advantage is the cultural agility that comes with someone who's willing to practice in a jurisdiction other than the home jurisdiction. It's a given, however, that that person must be qualified and considered an expert in his or her home jurisdiction before cracking into the international market. We all have to start as good national lawyers before going internationally. I mentioned a drawback, which is you can't usually practice in the courts, and we're all litigators to start. Arbitration's a procedural skill. But I think it's the agility that and open-mindedness that comes with that move.
Yeah. We also received a question from Haratsimi here on the chat, who was asking whether it would be beneficial for young practitioners perhaps to develop in, and I quote, least developed countries, for instance, or Latin America, where there are a lot of cases, but where you can have actually a lot of experience on arbitration cases.
What's the question? Sorry.
Yeah, I think that the question is really whether it would make sense to move to, let's say, least developed countries. That's how it was quoted. And so probably move away from the typical arbitration hubs, let's say London, Paris, New York, where it's really competitive, but perhaps focus on jurisdictions where you can work with local counsel and get involved in.
Yes, theoretically that makes a lot of sense. And I've seen it happen in certain new capitals of practice in my career. The problem is that, and I've heard this from clients from developing countries, when I've recommended that we use local counsel or appoint an arbitrator from that country, and they say, what, you think I'm not entitled to have one of the greats from Paris or London or The Hague or whatever? Do you think because I'm third world, I need to have a third world arbitrator? I shouldn't have someone from another country, from one of the leading countries, and I don't know how to answer that ethically. I really don't. I think that arbitration is a small practice area, and there are going to be hubs for a long time. Maybe the virtual world will thin that out a bit.
Going back to what we were discussing before, the sort of difficulty perhaps to practice in local courts if you're not qualified in the jurisdiction where you are working in arbitration. So in practical terms, what would you recommend to our young practitioners if they move away from their home jurisdictions to practice arbitration and they're not qualified in that host jurisdiction? Should they qualified in that jurisdiction? Is not essential? What's your view on that?
I think my answer is limited to what I experienced at Freshfields, where we had a lot of foreign lawyers in our core offices, and I didn't find it important for them to qualify in Paris or London or New York, whatever, unless they intended to stay in practice. I think what's important in that situation is to make sure that the arbitration caseload of the firm that you're going to is large enough to keep you busy in arbitrations without having to do local litigation. And there's still a relatively small number of firms who offer that possibility. And, you know, I practiced in London and Paris and The Hague and Singapore and Hong Kong, but that followed the work. I didn't go to those places and hope to get work. I went to those places because the work required me to go to those places. And that's the ideal situation. It's luck. I encourage people to take their chances and go to a different country to try to get work. But that's not how it happened with me. I can't claim that much luck.
Okay, thank you, Professor. I'll move to Panos, I think, because we are really running out of time. And I think that we can discuss again with him how to get your first oral advocacy experience. So the floor to Panos on this point. Thank you.
Yes, so we are now coming to our last topic for today, which is how to get your first oral pleading experience. And the first question that we have is to ask you, how did you get your first oral pleading experience?
Well, that was in the DC courts, as I mentioned, in the pro bono case where I was on my own. I'll anticipate a question, Panos, which is the best way for a young practitioner in an arbitration group or practice to get the first oral advocacy is to have a senior colleague who can convince the clients that it's to the benefit of the case to have young voices and different voices in an arbitration hearing, and not just 3 hours nonstop of the famous senior person who's going to be boring. I don't care who it is. That's what we did at Freshfields in our CMS Argentina case. I believe the first oral advocacy experiences came up for 5 or 6 people who are now leaders in the field, because the client said, okay, Lucy, I believe you. The arbitrators want to hear different people. So there you go. And I wish as an arbitrator that more senior partners would do that for their younger associates.
And what skills do you think a junior practitioner should develop in order to get that first oral pleading experience?
Well, I think written advocacy is far more important than oral advocacy, so I like to see most effort go into that. But here's where I think VIS competitions or VIS or any moot is very important, because you can practice without consequences. And I always say to people, when you're going to do a moot, or say in your own little practice, you're going to do a practice moot opening or a cross-examination with a hypothetical situation, don't just do it once. Do it 3 times, do it 5 times in order to learn from your mistakes. I just doesn't help. I always say it's like skiing. You can go down a slope once, but if you don't keep going down the same slope, you're not going to learn how to do it well. So at Freshfields, we always tried to get the young groups to go through a mock exercise 5 or 6 times, again and again, trying to practice what they learned. And that's what you can do that over lunch hour with your friends. You can do it on screen with your friends. pick a simple hypothetical, a scenario, cannibalize something that's already out there, and do it more than once.
Thank you very much. Now, before we open the floor and we get questions from our participants, we just wanted to ask you a few more personal questions because I think our members are interested in getting to know you as a person. So one of the questions we wanted to ask you is, what is your favorite book? And of course, it shouldn't be an arbitration-related book.
That's a hard one. I think generally the book that I've read the most times over is 100 Years of Solitude. I've gone back again and again to that. And the book that's my favorite right now is East West Street by my friend Philippe Sands, which is a legal thriller, if you were, that connects to the development of the words genocide and crimes against humanity. It's a very, very compelling book. But if your spouse or partner or friend is not a lawyer, tell them to start in the middle, not for the first half. I had to coach my husband through the first half of the book.
Okay, and what would you say is your favorite food?
Oh, a lot of foods. Probably anything Indian vegetarian is my favorite. Mediterranean too. A little Italian. Okay.
I'm sure Camilla must be feeling very proud right now.
Of course. Thank you. And you too.
Yeah.
I just made clam pasta with prosecco, which was excellent here.
Well done.
And one last personal question: what is your favorite hobby other than practicing law, of course?
You know, this is really going to disappoint you. I thought about this, but I think my favorite hobby is doing nothing. Lately, having been so busy with such a packed life of practice and family and friends, I just like looking around, taking a break, taking a walk, taking a drive, and letting my thoughts sort themselves out. I have a lot of small hobbies, and to be fair, it's spending time with my family. We have 2 grown children who are absolutely delightful. It's nothing better than to be this stage in our lives and have 2 successful children. No lawyers, by the way, no journalists, not at all. Okay.
Thank you very much. Theo, do you want to take over?
Sure. We are a little pressed for time, but I still want to put some questions to you that we got, some of the live questions. So one of the questions that we got from Orlando was, how would you suggest to develop a practice and what strategies should young practitioners use to obtain cases?
I think it's extremely hard to develop a solo practice as counsel in international arbitration. You'd have to have a lot of luck and be in the right place at the right time, as a few people were with the Iran-US Claims Tribunal situation. I think it's to join. I always say to people when I was at Freshfields or counseling, try to get a position at the very best law firm or practice in your jurisdiction that you can. And maybe it will be good training. Maybe it would be better to be at an institution or to teach for a year. But the fact is, from the perspective of the outside world, 2 to 3 years at a good law firm, they're not going to know if you only did document disclosure, is an entry key to the practice. So that's the best advice I can give. Go to the best practice you can and stick it out for 2 to 3 years to show seriousness, and then move on.
So one of the other questions that we got was, how does a young arbitration practitioner with not a lot of experience, how do they seek to gain experience, and how do they develop soft skills like cultural awareness in their practice?
That's a very big and a very hard question. I start with the caveat I always give, which is that international arbitration is a very small practice area. My observation is many more people want to do it then there's going to be room for full-time, make a living practice. So and my students, I struggled with that with my students. So what I say is this: the skills that you learn in international arbitration training, whether you're an LLM or whether you're going to conferences or listening to interviews like this, they're useful even if you're never in an international arbitration. They're useful in dispute resolution, they're in your life, in litigation, they're useful in negotiations, they're useful in cultural awareness. So yes, pick up the soft skills as well. Get familiar with principles of civil as well as common law. Get familiar with the different body language and manners of the different cultures you're going to be working in. Most important, I always say this: watch before you speak. In a new situation, take the temperature, don't take the stage, stand back and figure out what to do before you do it.
Thank you. I think that's a pretty fair point. I have one last question before we wrap up the webinar, and it's from Lou France. I hope I pronounced that properly, but they wanted to get some further clarification on your statement as to inclusivity of developing jurisdictions in international arbitration. And they wanted to know the role of ICCA in the development of international arbitration in newer or emerging jurisdictions.
Well, inclusivity is important, and it's one of the strengths of ICCA based on, if you look at where our members are from. I think that, as I say, that conversation is going on. The hard step, and I said this in my ITA ASIL lecture on why our practice is too inclusive, in a sense. We welcome everybody for training, but we don't do enough to create enough opportunities for action and practice for diverse nationalities, whether regional or race, anything. I guess it's persistence and not giving up, and what it's taking the idea of the pledge, thinking harder, acting harder, to go beyond gender. But again, it's a small practice area, and in the big cases, there are billions of dollars depending on expertise. There's very little room to say at the top, oh, let's try somebody new or someone who's never done a case. It's a long apprenticeship. There's no way around that. It's the last thing I'll say. I am promoting, from my dear and also lost friend David Caron, his rule of X, which is urging arbitrators to take no more cases than they can responsibly manage and leave the smaller cases that don't bring great value to them or require their skill to the younger generations. Don't hold on to things that don't need your expertise. Expand the pool that way. I'm writing a new paper on David Caron's rule of X in that regard. It's squarely on our shoulders, not on a code of conduct, not on another IBA rule, not on an ICCA rule. It's our own personal responsibility to make more room, which is what I do with women. I turn down so many things and instead say, well, ask whatever, Sylvia Nori, ask so-and-so, ask so-and-so. And that's why I'm excited to learn more women at Young ICCA. So I have more names to say, you want more women? Great, I'm not doing it. Call these people. I consider it that's my responsibility. To circle back, that is what my non-mentors did with me. They said, we could do it, but here's Lucy. Let Lucy have a chance.
Thank you so much for that. I just want to take a quick moment to wrap up and thank you for joining us today for this webinar and for this interview and asking and answering and putting these ideas in our heads. So many questions. We really appreciate it. One of the key takeaways, I think it's very important to remember as we move on in our career or the long apprenticeship period, as you mentioned, is to accept the setbacks and to learn from them. I think that's a very key point that you made. Again, we want to thank you on behalf of Young ICCA, my co-chairs, Camilla and Panos, and also the Global Events Director. We want to thank you. We also want to thank the ICCA Bureau, especially Lucy Burns, for all of her help in setting this up and keeping us organized. We want to thank our participants. At one point, we had well over 100 participants on this webinar, and we also got a lot of very interesting questions that unfortunately we weren't all able to address due to time constraints. But thank you again to those who signed up, registered, and spent the entire hour and some with us, and for continuing to support Young ICCA. So thank you again.
Thank you all. I look forward to the work that we'll be doing together at ICCA going forward.
Thank you.
Now I'm going to get another cup of coffee. Bye-bye.
Bye. Thank you, everyone.